and given the topic and the readings that you have already received, you can see a slightly complex one, and an attempt has been made to respond to the observation of Professor Tyagi on the first day, to also look at the practice of administrative bodies in the context of interpretation of the law. But before we will do it, some very general and preliminary observations. Forms and parts of interpretive text. As far as forms are concerned, at the national level, the most usual form of written law is what we know, what is called the statute. This is an English term, but is very well used nowadays, even outside of countries which were at some point in time British colonies. Legislation in generic sense. Legislation, and the main form is statute. In other words, an act of the body competent under the constitutional law of that country to enact the law. The statute basically is an enacted law. This is not law which is made by any organ otherwise than by way of enactment. In other words, this would exclude regulations, bylaws, administrative instructions issued under a statute. It is a statute that is at the national level. At the international level, the most usual form of written law is treaties, agreements. There is no need, if we should go by the Vienna Convention or the law of treaties, there is nothing substantial in the nomenclature by which states have consented to be bound on a text which they have signed and ratified and which for them is enforced. So a treaty may be called a treaty, an agreement, a charter, a covenant, even an understanding. So if a text is called an understanding, it may not be less than a treaty. So please do not go decisively by the nomenclature adopted. So these are the typical forms of written law which are usually the subject of interpretation at the international level and at the national levels. Parts of written law, treaties and statutes. If you make a general survey of written laws at the domestic level as well as at the international level, you would certainly find a preamble to a treaty or to a statute. It is most a treaty or a statute most usually begins, you see, with a preamble. Sometimes the heading preamble is written and then you will follow, you would see the text follows. Sometimes preamble as such is not written. The point is, it is generally agreed that it is the preamble of a treaty or a statute where you will find the legislative expression of the statement of objects and reasons, as you call at the national level, a statement of object and purpose at the level of international. Sometimes there is a title which is a very long title given to treaty, or long title given to a statute, but this is not the case usually. There is certainly a name given to a treaty, name given to a statute. Sometimes it is merely quantitative. It is not expressive. It is not descriptive title. But that is again an usual one. Some way of identifying. Right to Information Act, for instance, is a statute. Vienna Convention on the Law of Treaties is a treaty. WTO Understanding on Rules and Procedure Governing the Settlement of Dispute is a treaty. Montreal Convention is a treaty, you see. So you find, you see, there are, usually you will find a preamble. The interpretive relevance of a preamble has been the subject of litigation in this country as well as outside. At the international level, it is generally believed that preamble is part of the law where it occurs. It is not an operative part independently of the major enacting part of the statute. The major enacting part of a statute or at the international level of a treaty, however called, in the first case, it is what is called a section. Sometimes there is no heading as such which is written called section. But each number preceding an expression is understood at the national level to be a section or an article. At the international level, most usually an article. Section or article will be used interchangeably. Section and article are intended to be and have been a self-contained provision usually, not invariably and always. Sometimes a section is modifying or is modified by other sections, other provisions in the statute. So section and articles, these are the main enacted form of written law, the national level and international. Wherever you make a claim before a tribunal, you cite, you make a complaint that your rights have been infringed. Unless you identify an article, your claim is simply inadmissible. You know it at the national level. If you have not made, reference to an article, you can modify your writ petition only with the leave of the court. At the international level, if you have not mentioned an article, this is not the occasion I should give you the exact name of the case and tell you, but I will definitely tell you. The tribunals have gone to the extent of clearly stating, you have not mentioned this article by the number, we will not admit your claim. The party was saying, no, we have, you see, in expression, we have been arguing, this is our position, this and that is that. You have not mentioned this article, this claim is outside of our standard of review. So, it is the main enacting form. What parties would usually do, would use an expression called including. If you do that, then even if you miss a particular provision, it is by way of the interpretation of the expression called including is included. So that is, you see, the main forms, main parts of a the section and articles. I am giving you some very, very important elements. Otherwise, there is a long list. There is no point going through that list. You can read it elsewhere. So once you have sections and articles, then another very important form is some form of derogations. I am deliberately using an abstract word. Forms of derogations. Now, what are these forms of derogations? These are expressed in written law by the most common word called exception. Second, proviso. Non-obstant clause. Fourthly, saving clause. And fifthly, explanation. Very quickly, you see the Right to Amendment Bill 2013 uses the expression explanation. It is essentially an exception, but not called an exception. I will leave it to your imagination in the form of questions later on. Then I will explain, but not at this stage, why do they do so. You have Article 286 of the Indian Constitution with reference to Bengal immunity case. An exception was stated as explanation. Very quickly and briefly, there are obviously differences in nomenclatures, as we can see. Exception, non-obstant clause, saving clause, explanation, proviso. But it is basically the essence. It is basically the operative meaning of that particular enactment, which is decisive. In other words, for instance, it is very difficult for anybody to argue that Right to Information Amendment Bill 2013, which states as explanation that whatever political parties will not be treated as public authorities, is not an exception. But it is not called an exception. So the point is this: it is not basically the nomenclature, it is basically the essence of the provision. That is very important. So you have positive enactments in written law sections and articles, and then you have these kinds of derogations. So the generic word is derogation. These are the forms. In some treaties you will find, yes.
Reservation or declaration, then plus can we say this under the derogation form?
Yes. Reservations you see appended to a treaty. Declarations. Reservation is a category which is very well stated in the Vienna Convention itself. But what we are referring here is not those categories which are expressly stated, but those categories which are not expressly stated or expressly distinguished. You intend to do an exception, but you don't write exception, you write explanation, you write proviso. You see, the point is, exception is the most, you see, clear form of stating that we do not want to include this. This is used, for instance, Commission of Inquiries Act uses the expression exception, not a proviso. Right to Information Act mostly uses provisos and explanations, including this bill, which in due course is going to be part of the Right to Information Act. So the point is this: you have to see basically what it does, what is the function of these enactments rather than the names given to them by the legislation. Then some clause, some provision, some section, some article of entry into force. You have to have somewhere in some form of statute or a treaty, whether or not it is stated. Mostly, as far as treaties are concerned, mostly there is a distinct article which is stated as entry into force, which talks about entry into force. Reservations, you see, you will mostly find there are expressions used because it is used there in Vienna Declaration. At national level, reservation as such is not stated. I haven't come across a provision which talks about reservations. This is essentially an international nomenclature. You can find corresponding provisions there in the statutes, national law, but that is not a term which is used in the national law. So these are basically the forms. Sometimes you also will find in the written law notes alongside sections or articles. These are called marginal notes. Notes on the margin of the enactment to which they are appended. The first observation that you need to note is marginal notes are not legislative expressions in the sense that they are not voted upon by the members of the legislature. They are mostly editorial device added once the draft of the bill is prepared to give in a precise form the meaning, or we can say the representation of the section. So this is, you will find marginal notes. You go to the Indian Constitution, you will find both the sides. But the main point is, this is not, you see, legislative expression. This is not voted. Then you have headings given to the chapters where sections are enacted. Headings are legislative expressions. So there is a contrast, but there is a common point between marginal notes and headings in the sense that if the text of the heading, text of the section is unambiguous, obviously, unambiguous to the court, not to the party. Obviously, one party would always say it is very clear to me, as you can see in the case of Colombia and Peru. The other party will say it's not clear. If it is unambiguous to the court, there is no further reference, no further function is left as far as interpretation is concerned to headings or to margin. Having said this, you see, we come to the cases and we will see how these forms and parts have been the subject of interpretation. I have given you a case called Chevron, an NRDC case. Let me tell you, this is one case which is perhaps the most cited, and one of the most cited cases in the interpretation of administrative law. Everywhere, not only in the United States but everywhere. Any administrative body seeking deference to its interpretation would do very well to cite this case and would almost invariably cite this case. The question here is, let us try to recapitulate the critical facts of this case from the point of view of interpretation. What was the issue in this case? Let us please find out what was the problem in this case? What led to interpretation? What was the problem? What was the interpretive problem, to be more specific, that the court was facing?
So the main issue was that whether to grant deference to government agency or not. Whether court can interpret the executive, delegated legislation made by the executive agency as in the United States position that federal agencies were delegated to enact certain rules and
Absolutely right. What you said is absolutely right. But what was the interpretive problem? What was problematic? What was the problem there in the statute?
the question before the court was that whether court should the question was text regarding the grant of deference.
Sir, whether
That
the
was-
delegated legislation was within the authority given by the statute? Is it the question, the interpretative question?
More specifically, please find out what was the interpretive problem. What was the statute in question?
Means it was basically related to standard of review.
True.
Standard of review adopted by the courts.
What was the statute? Can you name that statute?
So the EPE was in
EDA was the agency, the body, the administrative
Clean Air
body.
Act was there.
Clean Air Act of 1977.
Clean Air Act,
Amendment
Amendment
of
of Act,
1977.
absolutely correct. This is basically the statute. An amendment to a statute is a statute, at least part of the statute.
So basically, the environmental protection agency used interpret the word stationary source. So basically, the issue was that
This is certainly a very, very good observation. Certainly, it's a better reaction than you said. And one step, if you go further, the problem was this statutory word, stationary source, was not defined in the Parent Act, neither in the Parent Act, nor in the amendment. A statute or a treaty usually has an interpretation clause or a definition clause. The purpose of both these clauses is the same, is to define by the legislature the expressions which it has used in the law and which it intends to be given effect to in a manner defined by the legislature or on the international plane by the parties, by those negotiating states who have subsequently become parties to the treaty. Now, in this particular case, the EPA, the administrative agency whose purpose it was to effectuate, to give effect to the 1997 amendment to the Environment Protection Act, was confronted with a factual situation where it had perforce to define a stationary source. And the moment parties would find that the term is not defined by the statute, they would argue for and against, because it's $1 million question. It's all about business. Parties knew it. It was not. It was not a disputed fact. Let me tell you. Both the parties agreed. Tribunal also, the Supreme Court also agreed. It was not a defined. So the question is how to interpret it. The first thing that you conclude is there is a clear expression in the opinion of Justice Stevens that the legislature never intended that the single, I would explain, but let me put an expression, the single bubble concept was included in the expression stationary source. What was the single bubble concept? Stationary source, I hope everybody agrees, everybody knows, is stationary, A-R-Y. Stationary in the sense of a constant, which is not varying, which is not changing. A source which is a stationary source. So any device within the stationary source, no matter in how many parts, if emitting pollutants would be determined on the basis of this single bubble concept as was understood by the EPA. The EPA said, look, let us for the argument's sake, if total emission of pollution is to be quantified in kilograms, so if total emission is 10 kilograms per hour or per day or per month, no matter whether 10 ducts are used for pollution or 5 or 3 or 20 or 1000. This is immaterial. The EPA was saying that as long as the threshold of emission remains the same, if the devices vary, the source would still remain stationary. This was the EPA's understanding of the term stationary source. Now, from the point of view of interpretation, the legislature never expressed any difference, any favor for the single bubble concept. The court even went to the extent of looking into the legislative history, which the courts would not ordinarily do at the national level. I'm not talking of international level, there the approach is more, even before and after Vienna Convention, by the scheme of things of Vienna Convention. That is not the practice at the national level. But even in the legislative history, the court did not find any favor by the legislature of the single bubble concept. Now, first thing you agree, there was a legislative silence as to the meaning of the word stationary source. So we said one day, and today we have a very good occasion to give by example, that the main problem of interpretation arises. I am again taking you to the words of Holmes, Cardozo, both of them. The major problem of the interpretation arises only when the legislature has no intent. In fact, as far as the concept of single bubble was concerned, the legislature had no intent. Legislature neither said yes nor said no. In fact, there was no intention. It was not a for or against. Then comes the second question. If this was the state, or if this was the main reason, the facts, the second issue was the means by which to address this situation, how to redress this. Should the court accept the interpretation given by the administrative authority, or should the court substitute its own interpretation for the interpretation of the administrative authority? In other words, in the language of the judgment, should the court differ, give respect to the interpretation of the administrative authority, or should give its own interpretation? That is the issue. The court ruled that in such a situation, the court should give deference to, the court should accept the court should respect the interpretation of the administrative agency if its interpretation is reasonable. 1. 2. Its reasonable interpretation leads to the effectuation of the legislative policy of economic growth. 2. Third, reduction of environmental pollution. So the court not merely introduced as a precondition for difference the concept of reasonableness, not at all alien to the law students, but also linked reasonableness as an ex post facto determination to the legislative policy. In other words, if the agency's interpretation is not in consonance with the legislative policy, the court would hesitate to call it a reasonable interpretation, given the set of facts that Chevron had. So this is basically the situation. Let us summarize the point. There was a statute. The statute was silent as to a concept. The court was confronted with its interpretation, how to interpret it. The court found an interpretation given by an administrative agency. The court accepted it because the court found it reasonable, because it furthered legislative policy. Now, this is 1984. Then came the year 2001, and the Supreme Court had again the occasion to look into this particular, because this was very famous. This was path-breaking, you see, judgment given by the Supreme Court. In 2001, there was another case, the Meat Corporation case. Very quickly, now you should be smart enough to tell, you see, very quickly, 1, 2, and 3. Meat Corporation, the problem. What was the problem?
So it was the classification of the tax that earlier Meat Corporation was not classification of a tax by US custom, that they put 4% tariff on the corporation, which was earlier not levied on the Meat Corporation. The issue was that.
Yes, partly correct. Partly correct. Yes, somebody should say something more about it. Thank you for reading it. But without reading it, you could not have said this much. It's absolutely correct what you have said. Something more needs to be told in order to understand this. There was a tax, there was customs, rate classification, all these things were correct.
So the basic question was that should judicial deference should be used in classification of the used by the tax US custom.
Anybody else? You see, the main question in Meat Corporation case was, there was a change of customs classification. Please listen very carefully. There was a change of customs classification of a product marketed by the Meat Corporation. The product in question before change of classification was day planners. You must have seen it, it is part of stationery. Day planners. After change of customs classification, it was treated by customs as diaries. That was the difference. So it was a change. That obviously created a lot of problem. Day planner is a different product. Diary is a different product. Whether or not, you see, whether we will look into it through WTO jurisprudence, what is a like product or what is a directly competitive or competing product, is separate jurisprudence. The question is this: we should be sitting in this room, should not get judgmental. It is from the petitioner's point of view. Petitioner was saying, yes, you were doing it earlier, you were saying that it is a day planner, now you say it is a diary. Probably the petitioner would never have intended to produce at least as many diaries if we had known that this would be treated as diaries, because there may be some other people manufacturing diaries and he thought that nobody was manufacturing day planners. So please don't get into it that it's not. It's a very big deal about it. You may think it is of superficial or so simple. It's very important. Now, then what happened? This was the main issue. Main issue was this, that this was changed. The question before the court was, I think the Supreme Court was, whether to accept this or reject it. Anyone who has read this case, because there is a gap before this had happened and before the case went to the Supreme Court, something more than that, something had happened. You see, these customs classification is an executive act, and this is a ruling given by the executive. And this ruling has a force of law. The question is, if you change it, it will also have a force of law. The main point is whether the legislature had authorized to make a change in the ruling with the force of law. If it did, obviously Chevron would apply. If it did not, at least Chevron would not apply as had been the case. But the question was, the court said something more. The court agreed with the Court of Appeals, then Chevron would not apply. No difference to the interpretation given by the customs. But the court said something more. That is why it's a classic case again. The court said, while Chevron would not apply, no difference would be given, but it deserves some difference. Because of the need to respect the uniform interpretation by the administrative agency and the treatment of the issue by the administrative authority. In other words, on the basis of Chevron doctrine, difference was not available because there was a fundamental distinction between Chevron and in this case. Yet, it got a difference, not on the basis of Chevron doctrine. Here the court was saying it deserves some difference because there is a need to have a uniform interpretation of the law by the body competent to do it. It was not in dispute, then customs was not a competent body to give rulings. The whole question was whether this ruling, change of qualification, should be accepted by the court as a legitimate subject matter of difference. There the court did not. So in other words, when you read Chevron, please read Weed Corporation, because without Chevron, Chevron is still a very good law, but would today be incomplete law. In order to complete it, you have to read Weed Corporation, and that is the reason. You see, I gave you Weed Corporation. The court is saying the administrative agency had a specialized experience of interpreting the law. So even if it deserves no difference on the basis of Chevron, it deserves some difference. So the question was, difference was given. Reasoning was changed because facts and circumstances were changed. So that is this is again a pointer. Sometimes the court would reach the same conclusion. But the same conclusion reached by the court in a different case does not necessarily mean that the court had a precedent to rely on. Chevron was no precedent in this case, even if difference was given, as was the case in Chevron. I think you are entitled to a break at 4 o'clock.
Sir, I have
Yeah,
a
if you
question.
have a question, then we break for it.
Sir, in this case, the executive had this the duty. Executive has the power to classify the products according to the customs classification. They had the power, but the previous one was the executive act of interpretation of that provision, that term. So, is it different in the executive act, or there was a difference in the facts itself that made the case, both the cases different?
You see, the point was in the first case, the bubble concept, on the bubble concept, legislature had no intention. Legislature intent was silent. That was the point of just, the needle's point was this. From interpretation point of view, the agency's interpretation was contingent on the single bubble. That no matter how many ducts, how many silencers, how many sources are being used, but if the total amount of emission is the same, so the agency called it single bubble. This particular, on this point, on this methodology of interpretation of stationary source, the legislature was found to have had no intent. Now, in the lead corporation case, the legislature had a clear intent to have executive ruling to have the force of law. That was the difference. So, if this was the difference, Chevron should not have applied as it did not apply. The basic premises were different. So, therefore, in one case, difference was given. In another case, difference was not given on the basis of Chevron. Difference was given on the basis of something else. Chevron did not apply. Result was the same, reasoning was different. And reasoning was different because the fundamental facts were different.
Sir, if you will speak to the dissenting opinion in lead corporation case of
By Justice Scalia.
Yeah. It said that adherence to the Chevron principle or doctrine would lead, it should be required, and if what was held in this case is anachronism, the word used. Justice Scalia used the term anachronism.
Because Scalia was party to Chevron. That's the reason. That's the reason he dissented. And he is one of the very few judges who have dissented so well. Not in this case. I will read an article by Judge Scalia in the Duke Law Journal. It was 90s, I don't remember the year, but it is titled as Administrative Difference, Judicial Difference to Administrative Rulings, something like that. Duke Law Journal, I'm sure. Year 90s, I don't remember 5 or Duke Law Journal, where he has discussed this case. He has discussed two very important cases. One is Chevron that we are discussing, and one more case. I think Mead was also discussed. The Mead was not discussed, please.
So in Chevron case, it was also point that as a general rule, court should not interfere with the federal act of the agencies. As a general rule.
Yes, the question is, the court was not interfering. The court was saying that, you see, if the agency's interpretation is reasonable, let us put it very simply. The court said if the agency's interpretation is reasonable, we must accept it. We should not substitute our own view for the view of the agency. In other words, what the court is saying, and this is not the only tribunal which is saying so. I should give you a classic example from the WTO. Article 17, paragraph 6 of the anti-dumping agreement clearly says that if the WTO body should come to a conclusion, which is different from the conclusion of the national authorities going in for imposition of anti-dumping duties. The determination by the national authority should not be overturned simply because it is a different interpretation, as long as this is also a plausible. I don't think semantically there is much difference between plausible and reasonable, because reasons you have to find in both. Without reasons, obviously it is not reasonable, of which it is a semantic derivative. It would also not be a plausible interpretation without it. So it is also there. And in that context, read a fantastic article by John Jackson in the American Journal of International. The point here is, the court said it is a reasonable interpretation. Let the court should accept the administrative bodies. In order to determine whether it is reasonable, the court at least pointed out two things: the legislative policy, and recalled in the judgment of economic growth consistent with reduction of pollution. So, legislative policy was used as a necessary ingredient to determine reasonableness. That is what was Chevron. And Mead had no problem with Chevron, in the sense, because the fundamental facts were different. Obviously, Chevron would not apply. If you see an ordinary article on the stare decisis, it would simply be the facts must be not identical, must be compared. That was the question. Is something more. Mead still got difference. Reasoning was not Chevron. Reasoning was another case of 1940s of United States Supreme Court. It was saying that even if it is not reasonable, if because the agencies have a specialized experience, that is one reason. The second ground given was that there is a need to give uniform interpretation. Executive rulings of customs, please note from the judgment, this is followed by all states of the United States. This is not something insignificant, this is very significant. And on these two grounds, on the basis of these two grounds, the court, despite rejecting Chevron in this case, on the facts of this case, still gave a deference. Let us try and understand, Chevron was not the end of the world as far as deference to administrative authority. That is what the court is saying. Chevron was really a milestone, no doubt. But that was not the end of the world. Mead's message is this. Or Chevron would not apply if the facts are not comparable to Chevron. That is what it was. Any further questions? We go for the break. But if you have any question on the point, please complete it. We won't get back to that.
I'm unable to understand the logic that it has completely not negated the Chevron doctrine in Mead Corporation case, but also to put a rider for the Chevron case.
The question is, the facts of Chevron and Mead were different.
Yes, sir.
Therefore, Chevron did not apply. But the court said, it still deserves deference.
What does it mean, sir? Then again?
Yes, it gave two reasons. Because the agencies has a specialized experience of tariff classification. Number one. The second is the rulings given by the executive concerning tariff classification are uniform interpretation of the Tariff Act. These two grounds, if you read closely, these are the two grounds on which, even after rejecting Chevron, the court deferred the interpretation of the administrative authority. You have some Indian cases, but I could not find, so good Indian cases. There are some, but I don't find the literature that would give, cite these Indian cases is not very good. Therefore, I have included this RTI case. So that's a very hot case. So I would say that you otherwise be interested in saying something, and that is there in the legislative process again. And maybe I don't know. It will go to court. Let's break for 5 minutes. You see, one of the forms, as you might recall, at the international level, as a form of interpretive text, is the judgments given by the international court. At least there is one provision in the statute which may be read to this effect, that the judgment rendered by the court could be a subject matter of interpretation, and if it could be as it has been, then obviously a judgment itself is an interpretive text. On the domestic plane, at least with reference to the Constitution of India, it is possible to say that the law declared by the Supreme Court of India under Article 141 is the law of the land. And if it is the law of the land, certainly that particular judgment is interpretive text in a given case. For instance, Kesavnanda Bharati case was interpreted in IR Kohillo case, and we do not know in how many cases other Supreme Court cases will be interpreted. Just one example. Now, there was a case of this kind where there was a decision, there was a judgment by the court of 50s, 1950, Columbia Peru asylum case. That was given by the court. Now, in this case, Columbia believed that there were some gaps. Or rather, I should ask you, what was the problem in this case? I should begin with you. Please tell us, what was the problem in this case? Request for interpretation. Columbia asylum case.
So basically the issue was regarding the surrender of a political refugee. But after the judgment came and it requested to the ICJ with the Article 60 of the ICJ, and in that case the ICJ gave two conditions when in Article 60 the court.
Yes. Anybody else? You see, the problem was a very interesting representation of facts. Peru said that the judgment of the court, the original judgment, was clear. Columbia said it had gaps. What were those gaps? Can you tell us what were those gaps put forward by Columbia before the ICJ? One was this alleged gap. I should call alleged because this is a contention point made by the party. Whether the characterization of a political refugee by Colombian ambassador in Lima was correct. Look at it. I should again tell you. Look at the subtle nuance, how Colombia moved the court. Whether the characterization as a political refugee, political offender by Colombia was correct. And the second issue was whether Peru had the right, and if it had, corresponding to it, whether Colombia had an obligation to surrender Mr. Hayat Torre, that political offender. These were two gaps. Colombia detected that these were two gaps in the judgment. The court said, what did the court say? Any other gap which you found? Because Article 60 is very clear about it. Article 60 is very clear that if there are two alternative positions, whether of meaning of the judgment or scope of application, in either case this would become a question of interpretation of the judgment. If neither is the case, the question is not of interpretation of the judgment under Article 60. This was the law. Columbia was saying that this judgment had these two gaps. This was not clear to me from this judgment. Obviously, the court had to see it. So what did the court do? See, if you do not take a pause and read each and every expression, you see seriously, then you will not detect the methodology. How a tribunal proceeds. There are fresh arguments made by Colombia. Both Peru and Colombia were parties to a judgment which was given. One of the party goes to the court invoking Article 60, which says that if there is a doubt about meaning or scope of the judgment, then court will interpret it. Court will give its decision. This was the issue. How did the court proceed? What did the court say as regards these two expressions, these two gaps?
Sir, apart from object and scope, there is another thing in Article 60 that judgment is final and without appeal. So, in this case, the court said that the Columbia argument is inadmissible due to several reasons. 1, 2A, 2B, 3, 4. Court gave 4 reasons.
Yes. You see, but the submission of Columbia was not that the judgment was not final.
Yes.
The submission of Columbia was not that it was appealing from the judgment. The submissions of Columbia were to the effect that it required interpretation. This was not in dispute whether the judgment was final. It was nobody's case that either party could appeal the judgment. Neither was appealing or making an argument. The party's submissions, even when Peru says the judgment was clear, this is squarely an argument concerning interpretation. Because clarity or ambiguity is a question of interpretation. When you say a text is clear, you are interpreting it as clear, and therefore you are saying it is clear. When you are saying it is unclear, you have already interpreted it and saying that it is unclear. Whether or not your clarity or your unclarity is acceptable is certainly a judicial choice, of course, subject to so many judicial criteria of the court. One position will be accepted, but notwithstanding that accepted by the court, but before it remains a question of it. The court said, when we interpret original judgment, interpretation requires at the minimum a serious reading of the text of interpretation. When the court simply looked at the original judgment, the court found that neither submission by Columbia was made before the court. This was, the Columbia did not say that please tell us whether our characterization is correct or whether we would be under obligation to surrender if Peru had a right to get surrender of Mr. Hayar. The issue was, if in the original judgment these two submissions were never made, how can you discover gaps of these kind? You see, you can discover gaps only on the points of submissions. So the court in this particular case was saying that neither submission was made by Columbia in the original judgment. So therefore, the court believed that these so-called gaps in the judgment were in fact new submissions made by Columbia. And if new submissions made by Columbia, this was the case, upon a careful scrutiny of the original judgment, this cannot be a subject matter of adjudication under Article 60. For that, you have to seize the court under Article 34 or 36. You have to file a proper application. The court is saying, in other words, interpretation properly may not be a device either to re-agitate a point settled by the court or to bring in fresh claims under a provision which authorizes the court only to interpret an existing judgment but gives no jurisdiction to it to entertain as application new facts, new submissions. So this is very important. When there is no doubt about it, a judgment is an interpretive text. But the question is, when is a judgment, when is a submission of interpretation, and when is a submission is not a subject of interpretation, is basically a submission of new claims. This is very important. And unless you read the original case, you will not be able to appreciate whether this was the case. So in other words, Columbia never asked of the court to say whether the characterization was correct. The Columbia never asked of the court in the original case whether Columbia would be under obligation should the peril is held to have a right to seek surrender of the political offer. It's national. And hence, this was not a question of interpretation, and hence the request of Columbia was inadmissible. So this is very important. And sometimes parties will go to the court in order to, when you have an afterthought, that you cannot file another appeal. There is no possibility before the ICJ of filing an appeal. You can't challenge it otherwise. You have the option either of bringing in a new case or to re-agitate it in the form of interpretation. So the question is, every submission by a party is not a submission of interpretation, even if based on a prior judgment of the court. So these two submissions were not considered either of the meaning of the original judgment or the scope of application. There was absolutely no submission made by Columbia or Peru as regards the meaning or scope of the judgment. Both the claims were made by Columbia as fresh claims, and fresh claims are not admissible while adjudicating on the basis of a provision which authorizes the court to interpret a prior judgment. So this was, you see, one case of you can see a judgment certainly is an interpretive text, and sometimes this is an issue. At national level, you have several litigation. Most of the curative and review petitions before the Supreme Court are of this kind. Most of the time, they will go to the court on this point. Now, on administrative, you see, point I thought of including as a reading this very famous and very controversial decision by the Central Information Commission. I know of no other, you see, administrative or quasi-judicial, you might call it quasi-judicial, certainly it is possible to call it the Central Information Commission, but mostly administrative, of course, deriving jurisdiction under a specific statute, giving so many judgments, so many decisions in one day. No other body is giving so many decisions in one day. The list is, you can't even, I counted it 3-4 years before, more than 10,000 it had crossed at that time.
One of the most active.
Most active. Let us see, this is a very keenly contested issue. of interpretation of a public authority. In this, I haven't seen a more lengthy and I could say from the little experience that I have of Central Information Commission, so systematic a decision by the Central Information Commission. Hardly have seen so many lawyers appearing before Central Information Commission, including Mr. Prashant Bhushan. So let us see, and you have some very good authorities cited in this decision by the Central Information Commission. Please recall the important facts. Here was a statute, and the same statute, same ordinance is made in Bangladesh on the basis of a Central the Right to Information Act of India. You have ordinance. I have a reading. You see, you may have seen it. It is almost the same. 2008 ordinance of Bangladesh, Right to Information Ordinance, mostly made on the basis of Right to Information Act. But there, in the scheme of ordinance, Bangladesh, there are certain differences. In other words, the most striking difference that you find in Bangladesh ordinances, whereas the parallel provision in the context of Indian Information, Right to Information Act as public authority, there you have the expression authority. Bangladesh Right to Information Ordinance does not use the expression public authority. It uses authority. Whereas the basis for determining an authority are not, you see, much different, including as many things as the Indian, but it is rather more elaborate than Indian definition of public authority. But that aside, let us see this public authority. What was the issue in this particular case? Which
the petitioner,
yes, please.
petitioner filed a complaint that political parties are not providing the information under Right to Information Act, as their contention was that they do not fall under the purview of RTI Act, and as they are non-governmental organization. And the petitioner said no. Their contention was that as the government is substantially providing financial support in terms of exempting the taxes, as well as giving the land for to set up their political offices, and free channels on free time slots of air radio and all. So basically, they said the political parties vehemently, all the political parties, they vehemently oppose this judgment.
Was there anyone which supported Central Information Commission?
CPI.
Yes. It is true that most of the parties opposed the Central Information Commission's interpretation. Ex ante, of course, the submission they did not give information, and they said we won't give it because we are not public authority. There was one
NCP provided the information. The Nationalist Congress Party, they vehemently opposed, but they provided the information which has been asked from the petitioner.
So it was against
they provided the information.
it was a complaint against the several number of the parties. It was not only NCP. It was regarding the disclosure and of the funding status of the parties and their constitutional status of the parties. And the complaint was filed by this Subhash.
Not just funding. It was related to the manifesto, whether they have fulfilled their manifesto when they came into the power, or if they have not, and what are the conditions and what are the promises they have not kept. So what are the reasons behind it? These are many questions that which have been answered this particular.
absolutely correct. I mean, because you could see the questions were so specific. that one of the questions was that how many promises made before the elections in the concerned manifestos, how many of them were fulfilled? And they attached, the petitioner attached the manifestos of these political parties. You tell us 1, 2, 3, 4, 5, which one? It was this. Now, you see, please see the scheme of the RTI Act and then see the interpretation given by the Central Information Commission. Very elaborate interpretation, very elaborate. I haven't seen in any, of course, I have not seen more than 50, 60 decisions of Central Information Commission, but I don't think it is usual practice. How did it go about it? What did it say? You see, before concluding that all these political parties, 6 of them, were public authority within the meaning of RTI Act. What was the rationale? How did it build up its case within the definitions of public authority given in the RTI Act? What did it say? Grounds. Public authority. Public authority. Very simple. One is adjective, another is a noun. Authority is a term which students of constitutional law, in some sense, may be presumed to be aware.
Controlled and funded by the government.
Some references. There was a case which was not cited, of course, in this particular case. Of course, Article 12 of the Constitution was made reference to. The very famous case of Justice Bhagwati gave that decision. Ajay Hassia was 5 points test of a state. So one argument was that if the Parliament had intended it to be a state, then it would well have simply use the same expression. State and definition of a state, at least today, is well known, or well known by referring to certain decisions of the Indian Supreme Court. But the legislature did not do that. The legislature did not use the term state, it used the term public authority. So how did it go? You see, the Central Information Commission built up its case on the basis of 3 very important grounds for its reading of these 6 political parties as public authority within the meaning of RTI Act. One is the issue which is, even if expressly not mentioned in the decision, is certainly improvised on Ajay Hasya's Khalid Mujib test. One of the grounds, which indeed was one of the grounds in Ajay Hasya versus Khalid Mujib. That was the substantial funding of these political parties. An acceptance of the commission that substantial does not necessarily mean majority funding. In other words, if you need, your total financial requirement is 1 crore, so it is not substantial if you get 51 lakhs. Even if you get 5 lakhs, it is substantial. 5 lakh amount is substantial, at least going by Indian standards.
It depends upon the nature of the organization.
That is the one, you see, that is one ground that Central Information Commission took. Substantial funding by central government. The second ground was performance of public duty. Now this performance of a public duty, if you go refer to several law tort cases in the context of exemption from liability, Vidyavati case or steam ship case or several cases, or vicarious liability references to statutory authorities. Public performance of public duty is a very well expression, very well referenced within the meaning of domestic law. Public as well as private. So the second round was performance of public duty. It said that these political parties, they perform public duty. They issued it. It is very clear. You have food, you see, security bill before issue. You can throw any member out. These are, some of these, of course, I'm not saying these are the only public duty, but I don't think these are private. Attending political parliament and doing these kinds of things, certainly public duties. That is the second round was public duty. The third was vesting of rights and liabilities on political parties. So if a body is capable by law, it is basically, sometimes we say in international law or even otherwise, legal personality. One of the incidences of legal personality is to have rights, to ability to have rights, capable of having rights, capability to have rights, and to perform, to discharge obligations. So it is the vesting of rights and liabilities on political parties. That was the third determination which was made. And on all these three grounds, the Commission came to the conclusion that it is these six parties in question were political, public authorities within the meaning of Article, and rejected the arguments of all political parties. It also noted that one political party which gave information, although with the rider that we are not, by giving this, we do not accept that we are a political party, but we would nevertheless give information, we have not. These were the assets we have, and whatever, it also said in response to a certain questions, a prospective answer that this is what we are going to get in future, and we have no problem in disclosing it. Has even appointed a public information officer at its office, and everything in it. So this is basically, this is a decision of 3rd June 2013, and after that you are aware what had happened. A lot of debate, discussions, writings, some writings have appeared at least, and then response by the existing response in the form of a bill, which you have, and which says as explanation, that is very important to know. The bill doesn't say an exception, that any body which is which has come into existence wide representation of People's Act 1951 will not be treated, will not be a political party. It simply adds an explanation to Section 2H, and by which it simply excludes political parties from within the. Your reactions, your comments.
Sir, maybe they have thought that by putting the explanation, they are indirectly restricting the public spirited person to challenge the validity of that particular explanation. If they would have provided exception, it is quite possible that directly can be challenged in any court of law.
There is no doubt about it. What you are saying is certainly carries a lot of sense, which is basically cosmetic, and the appearance, as far as appearance is concerned, it doesn't state an exception, so it doesn't intend to convey an exception, even if what is conveyed is not anything other than an exception. what is accepted, what is explained by way of this explanation is basically taking political parties out. Nothing else. It even adds one particular provision after that, after section 31, that no decision contrary to this given by any commission or board body shall have effect, which of course is a directly, even otherwise from a different route, directly hits at the decision also. So there in the definition and then at the decision. See, in fact, in the total scheme of things, there is absolutely no doubt about it, and this is totally excluded. So this is how, you see, I included it because when you read Chevron or read, it's basically all is over. Then you are reading it. And here you have a thing in the process. So you have one explanation, one interpretation of the act. Then you have seen legislative response. Let us see what happens in Parliament. Let us become part of Right to Information Act, and then see whether it goes to the court. 1, 2, most probably it will, and then see the response of the court on this. Then we will be able to complete this issue from the standpoint of interpretation.
So what will be the sanctity of the interpretation? On the one hand, we are having amendment bill in RTI 2013. At the same time, we are going to amend, as party has made a consensus to amend People of Representation Act 1951.
Yes.
Then what will be the sanctity of interpretation?
What will be the sanctity of interpretation? Sir, you would like to say something?
Well, when institute itself does not have sanctity, how can interpretation have sanctity? Institute can be amended, institute can be overruled, institute can be abrogated. So institute per se is not the final word.
So this reasoning is justified?
What's the problem? There is no problem. Question of sanctity comes when the commission has given its order and the affected parties don't respect it. Then question of sanctity comes. But bringing a bill to amend the act is not an issue regarding sanctity of the interpretation. It's like when Supreme Court of India pronounces a judgment and then government brings a bill in Parliament to bring a legislation to overrule that judgment. So issue is not of issue of the sanctity of the judgment.
At the same time, there can be another issue. They can challenge the Supreme Court's order.
Yeah, obviously they can. Why don't they challenge it? They don't challenge it because they have no scope of securing different order. Same is the situation here. There are two options. One is to go to the Supreme Court and challenge the interpretation given by the Central Commission, Information Commission. Second is to bring a bill to bring an amendment to the Act. If they had taken it to the Supreme Court and if Supreme Court had upheld the interpretation, then they would have lost face, and there was a strong possibility that Supreme Court would have upheld it, and they did not want to take risks. They are very intelligent people. So sanctity question is not the issue. The issue is authority to interpret, and this is what Dr. Pratap is emphasizing. It's a beautiful example of how law is interpreted